A total of $3.1 million is what law enforcement seized from the mine beer company in Carmelita after a two-day raid in early October of this year. However, Caribbean International Brewery Company Limited believes that the raid was malintended. They say that law enforcement officers had no right to seize their cash. The FIU, on the other hand, says the money remained on lockdown at least for 3 months initially as they intend to demonstrate their suspicion that the funds were derived from unlawful activities. Well, the matter was back in court on Monday. However, as per our last interview with Dean Barrow, CIBS lawyer, he insisted he was taking the matter to the Supreme Court. But it appears that Barrow has changed his mind. Today, a calm Barrow was singing softly and to another tone. He has changed his position.
I opted for the judicial review because I thought that way I would have a chance, albeit slim, to get a stay. And if I would have been able to succeed in getting the stay, that would practically have meant that the money would have had to be returned. Going the route of the case stated would mean there would be no chance of getting that sort of interim order, and we would have had to wait until 8, 9 months, long after the fact, and then just try to settle for damages if we were still able to show that what the magistrate did was wrong. So that was the reason for electing to go the route of judicial review. When we, what we did was to apply, you guys are familiar with judicial review by now. It's a two-stage process. So you apply first for permission, for leave to bring the substantive judicial review. And if you get that leave, then the judicial review case proper takes place. But at the same time as you apply for leave, you apply, if you wish, for an interim injunction or for a stay of the proceedings that you are getting leave to challenge.
So that is that. However, when Senior Counsel Godfrey Smith for the FIU was called, he indicated he was not prepared because he had only been retained for his services over the weekend by the Attorney General, and so he needed time in order to represent the FIU adequately. Since Barrow had no objections, the case was adjourned for yesterday, Tuesday, but with demands on behalf of CIB's attorney.
You can adjourn the whole question of our application for leave. But in the meantime, I want to ask you for a stay of the proceedings that are to continue on Wednesday. And she said, well, come back tomorrow. This was on Monday. She said, come back Tuesday at 1:30 and I will hear you on that. And so that's what took place yesterday at 1:30. Remember now, the actual application for permission to go for judicial review has not yet been heard. That's been put off until sometime in December, perhaps even as late as January of next year. I made my case, and she declined to grant the interim stay. She said that when she looked at the balance of convenience, her position was that the harm has already been done to my clients. They're already suffering harm, and they seem to be managing. And so she did not think that it would be right to grant a stay, which would mean that they get back immediately their money, in effect, making the extended judicial review proceedings almost academic. She said that I hear you about your clients being prejudiced as long as the money is being detained. But, she said, if you succeed with judicial review, they can be compensated by a suitable award in damages. In other words, the loss that they're undoubtedly suffering from being operationally squeezed in consequence of not having all this money that they would use as working capital, that can be dealt with by a proper award in damages if you win down the road.
Barrow voluntarily withdrew his application for a case stated. His intention was to have a chance yesterday at arguing that $3.1 million be returned to CIB before year ends. He was unsuccessful. However, what he does have a chance now is to argue in court for CIB to be awarded for damages caused to the company. So is the saga surrounding Belize's other bear ending soon? While Attorney Smith says Barrow is dragging the process.
So we come to court this morning prepared to resume and continue this matter that has been dragging out for a long time, in an unreal way actually, only to be met by an application that the magistrate ought to recuse herself, meaning she should withdraw from the case and no longer sit on that. Why? His grounds, as far as we can understand it, is that when he applied for judicial review to the High Court, it was his client versus the magistrate and the Attorney General. I appeared on behalf of the Attorney General. I said so on record, and we argued that the decision that no stay, no injunction should be granted. His allegation is because of that. Well, the suggestion is that I am representing the magistrate, and therefore the magistrate will appear to be biased and should no longer sit.
Are you representing?
Barrow is now challenging the fact that the existing magistrate on the matter recused herself based on her jurisdiction and orders made basing himself that the orders are null. So then it begs the question, is Attorney Godfrey Smith representing the magistrate? Barrow defines his argument by saying that if Attorney Godfrey Smith was hired to represent all parties on behalf of the government, then it means that the sitting magistrate is also represented by Smith, who is an officer under the Ministry of the Attorney General.
When we got there on Monday and Mr. Smith asked for time, he indicated, as I recollect, that he had been just retained over the weekend by the Attorney General. He had been retained by the Attorney General, but to, as it were, represent all the Attorney Generals, all the agents of the state. That had to have included the magistrate. In my submission, the magistrate can't get the benefit of representation by Mr. Smith yesterday and then come back and sit today and allow herself to hear Mr. Smith in his representation of one of the parties before her when Mr. Smith has just represented her. Clearly, the man on the street, the test of apparent bias, is right away provoked. So what? There is a joinder of interest between the magistrate and Mr. Smith.
Our position on that is in judicial review proceedings where decisions of any tribunal are challenged. It's the decision, it's not the magistrate personally. So if I can draw an analogy, which you may be more familiar with. You go to court, two parties go to court, they argue a case, one side wins. The next side appeals to the Court of Appeal. What happens? The winning side, what does he do? He defends the decision that went in his favor. there's no conflict there if the matter is sent back to the High Court. So it's not the magistrate in her personal decision. It's a decision that one is dealing with. So questions of bias based on family connections, based on interests and so on doesn't arise. There are established grounds for actual bias and appearance of bias. In this case, the magistrate is not personally involved. It's the decision that we're arguing about. So I have no doubt that that application in the fullness of time will also not succeed.
Barrow says that if the magistrate stays, he won't even bother to fight.
As I've said to her, if she decides not to recuse herself, all we say is those submissions that we made to you, which are now the grounds on which our judicial review challenge is based. Please note for the record that we renew those submissions, but we're not going to come back and waste any time.
The FIU is convinced that the $3.1 million must remain under custody as an active investigation continues its process. The matter will be back in court on December 14th, 2022.